Good day! Welcome to Lawyer Up by NDV Law. This is Attorney Nikki de Vega, Managing Partner of Nicolas and de Vega Law Offices. In today's video, I will teach you the rule on the grant of separation pay in the Philippines. Because I know there are times where we have to retrench, and separation pay is a very important aspect of retrenchment. Separation pay has been defined as the amount an employee receives at the time of his severance and is designed to provide the employee with a wherewithal during the period he is looking for another employment. However, this broad definition must not be taken at face value. There are only limited instances wherein separation pay can be granted. These instances are as follows. First, if the termination is for any of the authorized causes under the Labor Code, employment may be terminated for the following authorized causes. Number 1, introduction of labor-saving devices. 2, redundancy. 3, retrenchment. 4, closure or cessation of business. And 5, a disease that the employee is found to be suffering and whose continued employment is prohibited by law or is prejudicial to his health as well as the health of his co-employees. Another instance where you have to give separation pay is when there is illegal dismissal and reinstatement is no longer feasible. An illegally dismissed employee is entitled to 2 reliefs, namely back wages and reinstatement. However, where reinstatement is no longer feasible because of strained relations between the employee and the employer, then separation pay is granted. And finally, separation pay can be granted as a measure of social justice where the employee is validly dismissed for causes other than serious misconduct or those reflecting on his moral character. In this instance, the Supreme Court coined separation pay as financial assistance and allowed it as a measure of social justice and based on exceptional circumstances. Hence, courts in their discretion may grant separation pay based on compassionate justice, taking into consideration the length of service of the employee, the amount involved, and whether the act is a first offense, the performance of the employee, etc., etc. However, the Supreme Court sternly warned that separation pay shall be allowed as a measure of social justice only in those instances where the employee is validly dismissed for causes other than serious misconduct or those reflecting on his moral character. However, where the reason for the valid dismissal is like habitual intoxication or say an offense involving moral turpitude like theft or illicit sexual relations with a fellow worker, there is no need to invoke compassionate justice, said the Supreme Court. In view of the foregoing, an employee is not entitled to separation pay. Let me emphasize, not entitled to separation pay when he is terminated based on just causes. More importantly, he is also not entitled to separation pay when the employee tenders his resignation. Let's go to the computation of separation pay. It is based actually on the ground of termination. If it's based on termination due to installation of labor-saving devices or redundancy, or the employee affected is thus entitled to a separation pay equivalent to 1 month pay for every year of service or at least a month's pay, whichever is higher. But in case of retrenchment to prevent losses, and in cases of closures or cessation of operations of the business, not due to serious business losses or financial reverses, including termination of employment on the ground of disease, the separation pay shall be equivalent to 1/2 month pay for every year of service, or at least a month's pay, whichever is higher. In illegal dismissal cases where reinstatement is no longer viable as an option, separation pay equivalent to 1 month's salary for every year of service will be awarded as an alternative. It must be emphasized that this payment of separation pay is in addition to payment of back wages. Please know that a fraction of at least 6 months shall be considered as 1 whole year. Well, if this video has been helpful, kindly subscribe to our YouTube channel by clicking on the subscribe button. You can also visit our website, ndvlaw.com, to learn more about legal matters in the Philippines. Again, this is Atty. Nikki de Vega, the managing partner of Nicolas and de Vega Law Offices, and thank you for watching Lawyer Up by NDV Law.